I would give them all the options of how they could discuss things between themselves. They could go to mediation, or they may want to try a series of roundtable meetings, which is called collaborative law. The way that would work is the parties are able to set the agenda for the meetings. So they could say, we've really got an important issue we want to discuss first of all about the children. Or they may say, we've got problems paying the mortgage, or we want to discuss about interim payments of bills, for example. So the way that would work is you would have both solicitors present at this roundtable meeting, but at the start of the meeting, the tone is very much set that this is it's not a cheap process to go through, but it's also far faster and cheaper than court generally, but it's a respectful process. So if people are able to deal with these issues and learn how to communicate better post-divorce, it will be better for the entire family. For example, if their children get married, they'll be able to attend the wedding without an awful atmosphere, or children's graduation, joint friends parties, for example. So it's a very respectful process. The parties are very much thinking, we need to resolve this issue now and also set the tone for our future relationship together. It depends on the case and what the issues are. If there's lots of issues, you would need more meetings. But generally, we have 3 or 4 meetings, normally for a couple of hours each. And the advantage of collaborative law is that you're obviously in the room with both parties and their solicitors, round table. So it takes away letter writing after the meeting, that solicitor's letter landing on the doormat. You do have an idea of the advice that the other party is being given, because the lawyers are giving the advice openly in the round table meeting. Collaborative solicitors have had specialist training to be able to call themselves collaborative law, so that they have learnt about the use of language, not to be adversarial or aggressive. So it's a completely different style of working to, for example, if you're in court. Collaborative law is generally very successful. Before you before you discuss collaborative law with a client, you will talk to the client about their relationship with their partner and what's led to the breakdown. It's effectively a screening process. If there's domestic violence or a real imbalance of power between the clients, then this is something you need to be mindful of. But generally, if there's been domestic violence or severe domestic violence, you wouldn't use that as a process. You may also want to discuss with the client as how they've dealt with conflict in their marriage, to see whether that is also conducive to collaborative law. If they say, oh, conflict is there's, screaming and shouting, that's not generally the best sort of client. It doesn't suit everybody. If you have clients, however, who say, well, we're normally able to talk things through, it might get a bit heated, and it would be very helpful to have a solicitor, but both solicitors in the room, to sort of pull us back together for our focus of what we're trying to achieve and sort things out in an amicable way so we can move on. Those are the sorts of clients it would suit.